I have submitted my article on the subject of challenges faced by family courts in Pakistan, an examination of the legal and social landscape. Dear friends, as you all know, that separation or divorce is always an act between, is a private act, an act of individuals. It is not an act against society, or it's not an act against state. Yet, unfortunately, one of the spouses in our family justice system is being treated unfairly, and the other spouse is being treated with more rights than anyone desires. I would like to take the attention of this forum to the fact that around there are 40,000 divorces occur every year in Pakistan, on the lesser side. And the laws that regulate or deal with the family issues are the laws that are couched in Guardian Wards Act that was promulgated in 1890, whereas the Family Courts Act was introduced in 1964. And both the acts that are regulating child custody jurisprudence or litigation in Pakistan calls for the concept of sole custody, whereby one of the parent was granted the whole of the custody as well as the visitation rights, whereas the other parent is usually the non-custodial parent, which is the father, is granted minimum rights and access even to his child without any justification, without sending any reason thereof. My friends, you may have witnessed that in Pakistan, the maximum access what a father is usually being granted is 2-hour visitation under the provisions of Section 12 of the Family Courts Act, under the provisions of Section 12 of the Guardian Wards Act, whereby the 2 hours visitation has to be concluded or has to be carried out within the court premises of the court in contravention of the provisions of General Clauses Act or the principles of natural justice, without assigning us any reason thereof as to why that visitation should be done for 2 hours or as to why that visitation should be done within the court premises. So I understand that the laws in Pakistan needs to be revisited to introduce a new concept of shared parenting. As per my understanding, sole custody is against the very welfare of the minor, and it usually marginalizes one of the parents to a total stranger. Therefore, I would be suggesting through this forum that certain recommendations should be sought from the legal community as to give a balanced and easy access to both the parents, because as per my understanding, the divorce or separation is always effected between spouses. It is never effected between parents. A child plays no role, no positive or negative role in the separation of its parents, then it should not be given any lesser right to have access to both of his parents. Secondly, in Pakistan, there are around more or less 195 tehsils, and in every tehsil there exists 3 to 5 family courts, and in every family court there are around 100 to 120 cases fixed, family cases fixed every day. At an average, we can say there are around 10 lakh cases pending adjudication in multiple family courts across Pakistan. And unfortunately, it is the fact that all the courts, in my experience for the last 22 years, I have not seen a single case wherein the custody has been shifted from one parent to the other. In large majority of cases, custody is being granted to the mother side while considering her to be the primary caregiver, while considering herself to be the better caregiver, and all the exceptions whereby custody can be denied or can be sought are practically denied by the superior courts. In this scenario, my lord, my dear friends, I understand that instead of indulging into adversarial long protracted litigation, we should introduce a concept that is different from the prevailing concept of sole custody. Instead, we should introduce a concept of shared parenting right at the pre-trial reconciliation stage, where the custody should be suggested to be granted to the one parent, and equal and appropriate visitation rights should be granted to the other parent, so that the parent who is being deprived of must not feel left alone or abandoned one. In this scenario, I have filed a writ petition back in those are 2013 to 2013, whereby a division bench of the Honorable Lahore High Court was constituted by the then Honorable Chief Justice, Justice Umar Ata Bandial Sahab, and they have called a report from the Applied Psychology Department, and the report was submitted before the Honorable Lahore High Court, and it was suggested in that report that maximum access should be granted to the children involved into litigation, so that they must become a positive citizen in the society. What we are doing is that we are usually engaged a litigation, child custody litigation carries on usually in family courts, and there are 4 tiers of courts in Pakistan: the family court, then the appellate court, and then the high court, and thereafter the Supreme Court. And if a case is filed in family court, it usually takes 10 to 12 to 15 years to conclude. And if a child enters into a court litigation at the age of 3 years, when the case is concluded, he usually reaches the age of 15 or 16 years. And in this regard, I understand that during the pendency of this litigation, kids involved into litigation and kids being retained by one of the parents, and the non-custodial parent is denied appropriate access to their kids, those kids are alienated, especially by the custodial parents, against the non-existent parent. And when the courts call those kids to interview as to whom they would like to accompany in the case of the custody, and usually the kid suggests that I want to accompany the custodial parent. I understand that this questioning of the child is against his welfare in the very first instance, against his human rights in the very first instance. The child must not be asked about as to which of the parent he wants to accompany in a custody litigation. As I've already suggested to all the members, that the child plays no role in this whole scenario, then by denying an appropriate access to the child, as per my understanding, is to punish a child for a wrong he has not done. Then I understand that in this scenario, there are around 12 lakhs pending cases in family jurisdiction alone throughout Pakistan. By introducing a concept of shared parenting, we can easily manage that pendency, that backlog of cases, by bringing quite a reasonable reduction in the pendency of the litigation, by bringing solace to the child himself, and by allowing both the parents to take equal opportunity in and to get equally involved in the life of the child, even after separation. जैसे कि here I would like to quote Quran, as Holy Quran suggests, अगर आप दोनों में आपस में नहीं बनती, मफहूम बयान करूँ, अगर आप दोनों में अच्छे तरीके से निभाह मुमकिन नहीं है, तो आप एहसन तरीके से अलहदा हो जाइए. हमने फैमिली लिटिगेशन तो शुरू कर दी, लॉ भी बन गया, कोर्ट भी बन गया. 80% से ज़्यादा, more than 80%, if you go through the petitions that are being filed in family jurisdiction, contains below the belt allegations against each other, below the belt false and fabricated assertions that could be brought to nil if we introduce a concept, if we introduced a practice of the provisions of Guardian Wards Act which harness the equality subject. अगर ऐसन तरीके को आप देखें और ऐसन तरीके को define करें, तो I understand ऐसन तरीका would be where both the parents or both the father and the mother has got equal access and equal rights to take decisions about the life of the child. And this stance of mine finds further support from the provisions of Section 15 of the Guardian Wards Act, which calls for the appointment of several guardians. Unfortunately, for the last over 22 years, I have been seeing that all the litigation in child custody jurisdiction pertaining to the visitation rights is being done under the provision of Section 12 of the of the Guardian Wards Act, Section 12 की application. And to my astonishment, I have not found a single application or the order passed by the honorable family judges, a single order deciding the visitation rights of the father, whereby any justification is being provided as to why the visitation should be within the court premises, or as to the justification being provided as to why the visitation should be for 2 hours. He is an equal parent. He does not become a lesser parent by just simply pronouncing divorce or his wife obtains a khula from her, he does not become a lesser parent, then why our judicial system is treating him as a lesser parent? I would be taking advantage of the presence of the Honorable Judge of the Honorable Islamabad High Court at this juncture and would place my suggestions in the form of recommendations that I have witnessed that for the last 22 years of what I have witnessed is there is a transfer and posting policy of being carried out by the judicial side of the honorable courts, whereby a judge who has been working in family jurisdiction for 3 years has abruptly been transferred to another city or another jurisdiction, and his jurisdiction is also changed. So what I understand is that we are just developing jacks of all trades instead of creating a master of one trade. I understand that a special cadre should be introduced in the recommendations I would be floating before this forum, that a special cadre of judges should be introduced. Those judges should be voluntarily invited to join the family cadre, and if they are being posted, they should be posted, but they should be posted in the family cadre alone. In this way, we can secure a lot of time, and we can secure a lot of, we can say, the time as well as the expertise. Secondly, I would be suggesting through this forum, while curtailing my presentation to a limited time as has been suggested by the organizers of this conference, to the suggestion that there is a provision of contempt in Family Courts Act under the provisions of Section 16 of the Family Courts Act, whereby the maximum punishment for committing a contempt is 2,000 rupees, a fine of 2,000 rupees. In the present scenario, in the present day time when the visitation rights are not being implemented, our courts are usually found toothless to get that order of visitation implemented. I understand that with that fine, the amount of that fine should be enhanced to at least 20,000 rupees, so that there is a threat or there is a fear of some fine. And secondly, I understand that to reduce the litigation and to ensure actual welfare of the minors being the best interests of the minors, we should introduce, or the judiciary or the legislature should introduce a new entry in the schedule attached with the Family Courts Act, whereby the concept of shared parenting, the concept where both the parents are equally responsible and should have equal access to the kids, should be introduced in the entry attached with the in the schedule attached with the Family Courts Act. Secondly, the concept of joint guardianship that has been provided under the provisions of Section 15 of the Guardian Wards Act should be revived, and the court should grant joint guardianship to both the parents to ensure actual welfare of the minor. There is no harm if the court should appoint multiple guardians of the minor, irrespective of their marital status or irrespective of their acrimony between the parents. And thirdly, I understand that as per my experience, with due apologies, I have seen that there is no specific subject-oriented syllabus of the presiding officers or the civil judges before they are being appointed as the judges of the family courts, or they are being appointed as the judges as guardian courts. I understand that a specialized subject-oriented syllabus should be developed for the honorable courts, honorable judges, and they should be trained to know as to the implications of contact denial, the implications or the fallouts of minimum access between a parent and a child, and they should be given training before they are being appointed as the learned, as the family judges or the guardian judges. And third and last subject my suggestion would be that the special training courses should be devised, and in this regard, the legislature, the judiciary, and the academia of the country should sit together and devise certain subjects to be trained, to be given training to the honorable judges, to bring the number of litigation or to bring the number of divorces to a halt. And that is very much possible. That is very much possible if we could join hands together to bring a decrease in the backlog as well as of the cases as well as of the divorce rate can be reduced. Thank you very much.